Good afternoon, everyone. Today is Friday, February 20th, and we will have our Judiciary Committee voting session. Members, you should have voting list number 4 and voting list number 5. For voting list number 4, we are going to begin with the end in mind. And that is, we're going to start with House Bill 593. And House Bill 593. Okay, voting list number 4. At the end of voting list number 4 is a bill that is 593. Delegate Hill, criminal law interference with critical infrastructure or a public safety answering point. This is where we're going to begin. Second. Are there any questions or discussion on House Bill 593? Delegate Valentine.
Just for the benefit of some of the members, was this related to a bill or very similar to a bill from 2024? I believe it was House Bill 70 that was voted on by this body.
Thank you, Delegate Valentine. Claire, would you like to answer that?
Oh, sorry. Yes, this is basically a reintroduction of House Bill 70 from 2024, which passed the House but was not acted on by the Senate. It's just, it just has some minor changes. It's kind of beefed up to add a definition of critical infrastructure, and then it's adjusted to reflect some statutory changes that happened between 2024 and now.
Does anyone have any further questions? And Delegate Valentine, did that satisfy the concern? I think Delegate Cardin. No, I was asking Delegate Valentine. Did that answer your question?
It did, and I believe that the vote on that was unanimous in 2024.
Yes.
Yes, the vote was unanimous. Delegate Cardin?
I'm going to support this legislation. I just wanted to indicate that I think $50,000 fine, maximum $50,000 fine is really high. There are very few penalties in state law that give you. We did find one that for violation of the Board of Physicians standard of practice, you could get a $50,000 fine. But that's very uncommon, but I still think that this is important to do.
Members, do we have any other questions? Delegate McComas, and move your mic, please. No. Yep, there you go.
I'm just thinking this is an important bill because it's infrastructure. And, you know, we had that incident several years ago where they wanted to blow up some of the power plants or something, the folks, and they went to jail. I'm just thinking it's not an emergency bill, is it? Can we make it an emergency bill?
It is not an emergency bill. Do you want to put in an amendment for an emergency bill?
Can I just do it by voice? I mean, I think we need to move it on, but I just think it's important that we get something in place. Mm-hmm. And I don't know, I'll defer to anybody that's in law enforcement if they feel we're in a good position now, but if they don't, then maybe we need to move it as an emergency bill.
Well, I don't think we can't do it by just a voice amendment. Okay. The reason why I'm hesitating is because this bill has been around for a bit, and it's never been an emergency bill. But if you want to put it in as an amendment for an emergency bill, it's something to consider. Well, I'm sorry?
It'll be in effect in 170 days.
Yeah, what we could do is, give me 1 second to confer with counsel.
Okay.
Okay, I'm back. Thank you. Thank you for your indulgence, everyone.
I just thought, like,
Okay. All righty. Thank you, everyone. I appreciate your indulgence there. So I have conferred with council. There's a couple of things going on here. One, like I said, it's never been an emergency bill. But the other thing is, we have to keep in mind that this is a criminal penalty, and all the powers that be need to have time to get it, to get it all set up. So I would encourage not to make this an emergency bill and stick with October. Okay, thank you so much for understanding, Delegate McComas. Delegate Conaway.
Thank you, Chair. Is there any consideration to what the good delegate spoke about, the 50,000 versus being a little too high?
Let's look at let's look at, are we talking on page 5, right? All the penalties?
Yeah.
And where's the 50,000? What page is the 50,000 on?
Page 6. Page 6.
I was thinking, Madam Chairman.
Yep, so page 6 gets triggered, and yes, in just a second, I just want to make sure everybody understands, and that I understand. The 50,000 gets triggered if you violate C7, where you are denying access or interrupting or impairing the functioning of a critical infrastructure of a public safety answering point. Delegate Cardin.
Yeah, I was thinking after I said that, Madam Chair, is that oftentimes if this is like a joint effort to try and impact an entire, I don't know, I was thinking like impacting traffic lights or something like that. Not only could you cause significant physical bodily injury, but you could cause a tremendous amount of economic harm. You're obviously a pretty sophisticated organization. You're doing this in a sophisticated way that 50,000 wouldn't be inappropriate for an organization like that or a person like that. So.
Okay, there's been a motion to move to the previous question. Delegate Conaway.
Yes, but on
He's not going to debate it. I think he has a.
I think it's page 5. On page 5, number 9, it says a person, so it's not saying a group.
No, but what it does, but several people could be charged with the same thing. And I understand what you're saying. It doesn't say a group. But what this person could do is jam up the entire 911 system.
Or shut traffic like that.
Well,
More than okay.
okay,
Thank you.
all right,
Thank you.
all right. We got Kumbaya going, and we have a motion to move the previous question. And it's been seconded. Okay, Hunter, call the roll. This is the vote for House Bill 593 as submitted.
House Bill 593, the Vice Chair. Yes. The Vice Chair votes in the affirmative. Delegate Valentine. Yes. Delegate Valentine votes in the affirmative. Delegate Embry. Yes. Delegate Embry votes yes. Delegate Cardin. Yes. Delegate Phillips. Yes. Yes. Delegate Phillips votes yes. Delegate Ngolo votes yes. Delegate Stinnett. Yes. Delegate Stinnett votes yes. Delegate Simmons. Yes. Delegate Simmons votes yes. Delegate Boucher is excused. Delegate McComas. Yes. Delegate McComas votes yes. Delegate Moreno. Yes. Delegate Moreno votes yes. Delegate Arcon. Yes. Delegate Arcon votes yes. Delegate Taylor. Yes. Delegate Taylor votes yes. Delegate Simpson. Yes. Delegate Simpson votes yes. Delegate Mangione. Yes. Delegate Mangione votes yes. Delegate Moon. Yes. Delegate Moon votes yes. Delegate Conaway. Yes. Delegate Conaway votes yes. Delegate Woods. Yes. Delegate Woods votes yes. Delegate Williams. Yes. Delegate Williams votes yes. 19-0-0.
Thank you very much. The motion carries, and House Bill 593 will go to the floor. I'm hearing Madam Chair. Do you need me, Delegate Woods?
I didn't know that
Okay.
you didn't have to call your name.
No, he doesn't have, no. Okay. So now we're going to go to vote list number 5. I'm going to move away from vote list number 4 to vote list number 5. This is the beginning. The first bill is House Bill 111, Delegate Griffith. It has 2 pages. These are all withdrawals. Second. Move unfavorable. Well, moved, thank you.
On a consent calendar, second.
Okay.
Oh, sorry. Third.
Oh, my God. Thank you, members. I love y'all. Okay, so it has been, okay, on the consent calendar, we are going to unfavorable on this. Are there any, is it only consent calendar, so there's no objections, correct? A question, yes, Delegate Taylor?
The monitoring about again?
It's withdrawn, it's gone.
Oh, it doesn't
It's
matter.
withdrawn.
Okay, it's not mine, so
Yes.
it's okay.
It's as if it never happened. All righty. Now, we're going back to.
Oh, we don't have to vote on, I guess we don't have to vote on the.
I just want to get clarity. We can, on those that are withdrawn, we don't have to do unfavorable, but on 111, where we're saying it was unfavorable,
No. 111, I only said that so you all would know which vote
which
list I was
calendar, okay.
talking about.
All right, I'm fine.
Yes.
I'm
Yeah,
fine,
I just
I'm fine.
wanted everyone to be on the same, literally on the same page. Yep.
Got it, thank you.
Okay. Okay, so I just want to make sure everybody understands. So this is our first withdrawal list. You do? It was a consent calendar, just to make sure everybody understands. Okay. Does anyone have any objection to the bills that are on the vote list number 5, starting with House Bill 111, to ending on House Bill 1544, all withdrawals? Does anyone have any objection? Does everyone agree? Please raise your hand. Okay, without objection, consent calendar is gone, passes. Okay. Now we're going to move on to vote list number 4. The first bill on the vote list is House Bill 53, Delegate Layman's bill. Is there a motion?
Favorable.
Second.
Thank you. Are there any questions? Delegate Ericon.
Thank you, Madam Chair. I know we talked about this, and I had added an amendment, attempted to add an amendment in subcommittee, but I'll just say for the record that there's actually a pretty large group of people in the U.S. who breed zebras and hybrids, and the bill in its current form does not differentiate between zebras and hybrids, and so we are essentially leaving it up to the court to figure out if we meant to ban the ownership of hybrids. I also have concerns that folks from out of state, while the people here would be grandfathered in, if you move to a farm here and you own one of these animals, you will not be able to bring that animal with you, which are typically treated as pets, not really as livestock. So you would be denying someone from moving into Maryland with one of their pets. So I will be a no.
Thank you, Delegate Ericon. Any other questions, concerns, comments on House Bill 53? Seeing none, please call the roll.
House Bill 53, Criminal Law, Non-Domesticated Animal Prohibitions, Alterations. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes no. Delegate Stinnett. Delegate Stinnett votes yes. Delegate Simmons. Delegate Simmons votes yes. Delegate Boucher is excused. Delegate McComas.
No.
Delegate McComas votes no. Delegate Moreno.
Yes.
Delegate Moreno votes yes. Delegate Ericon.
No.
Delegate Ericon votes no. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson.
Yes.
Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes no. Delegate Mangione votes yes. I apologize. I apologize. Delegate Moon. Delegate Moon votes yes. Delegate Conaway.
Yes.
Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes yes. Delegate Williams. Delegate Williams votes yes. Madam Chair.
Prince George's County with some zebras several
Can you
years.
move your mic to you?
Oh, sure. I'm so sorry. Just in, we had a little situation in Prince George's County a couple years ago with some zebras that got loose and ran a little rampant. Not certain if this bill would address that specific issue, but definitely in favor of the measure. So thank you.
It did address it, actually.
Oh, it does address our wild.
And what was the vote tally?
15-3-1.
I'm sorry? Okay. We're going to move now to, so we're going to have House Bill 53 on the floor. We're going to move now to House Bill 95. Delegate Simmons. Delegate Simmons, do you want to tell us what this bill does?
Yes. Family marriage license alteration. This is a result of the court systems, the clerks, they testified before this committee, just trying to make a change to their system in reference to when individuals are applying for licenses throughout our state, that this would put a mechanism in there for them to be either present or with an affidavit giving the clerks the authority to waive their presence for the purpose of issuing a marriage license.
Thank you. Is there a motion? There are amendments. And that is what this means when it says amendment and I got it.
Second.
Okay, all righty, let's talk about the amendments. Lauren, do you mind talking about the amendments?
The amendments just.
Okay.
The amendment, it just establishes exceptions to the requirement in the bill that both parties to be married appear before the clerk to apply, and the exceptions are military service, hospitalization, incarceration, or other good cause shown.
Thank you. Are there any questions? Okay, it's been moved. The amendment has been moved and seconded. All in favor of the amendment, please raise your hand. All right. All opposed? Seeing none, the amendment passes. As amended. Second. Okay, thank you. On House Bill 95, are there any questions on the bill as amended? Seeing none, the clerk will take the call.
House Bill 95, Family Law, Marriage License Applications, Appearance in Court. The motion is favorable with amendments. The Vice Chair. Vice Chair votes aye. Delegate Valentine. Yes. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Aye. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Yes. Delegate Stinnett votes aye. Delegate Simmons, the sponsor. Yes. votes aye. Delegate Boucher is excused. Delegate McComas. Aye, yes. Delegate McComas votes aye. Yes. Delegate Moreno votes aye. Yes. Delegate Arcon votes aye. Delegate Taylor. Aye. Delegate Taylor votes aye. Delegate Simpson. Aye. Delegate Simpson votes aye. Delegate Mangione. Yes. Yes. Delegate Mangione votes yes. Delegate Moon. Yes. Delegate Moon votes yes. Delegate Conaway. Yes. Delegate Conaway votes yes and add. Delegate Woods. Delegate Woods votes aye. Delegate Williams. It's House Bill 95. Delegate Williams is a yes and an add. The motion passes 18 to 001.
Hearing none, the clerk call the roll.
Justice Restoration Act, the motion is unfavorable. The Vice Chair. Yes. The Vice Chair votes aye on the unfavorable. Delegate Valentine. No. Delegate Valentine is a no on the unfavorable. Delegate Embry. Delegate Embry is an aye. Delegate Cardin. Yes. Delegate Cardin is an aye. Delegate Phillips. Delegate Phillips is an aye. Delegate Congolo. Delegate Congolo votes no. Delegate Stinnett. Delegate Stinnett votes yes. Delegate Simmons. Delegate Simmons votes yes. Boucher is excused. Delegate McComas. Delegate McComas is a no on the unfavorable. Delegate Moreno. Delegate Moreno is a yes on the unfavorable. Delegate Arcon. No. Delegate Arcon is a no. Delegate Taylor. Yes. Delegate Taylor is a yes. Delegate Simpson. Aye. Delegate Simpson votes aye. Delegate Mangione. No. Delegate Mangione votes no. Delegate Moon. Delegate Moon votes yes. Delegate Conaway. Yes. Delegate Conaway votes yes. Delegate Woods. Aye. Delegate Woods votes yes. Delegate Williams. Yes. Delegate Williams votes yes. The motion, and the chair votes aye. 14. The motion for unfavorable carries 14 to 5 to 1.
Okay, so now we're going to move on to House Bill 284. This is the Public Safety Licensed Firearm Dealers Bill. We have an amendment in the file. So are you moving the amendment? Okay, and I heard a second. It's been moved and seconded on the amendment. Claire, do you want to talk about what the amendment, Holly, do you want to talk about what the amendment does?
Sure. This amendment, get up real fast. This amendment was work with a couple groups, MSP, Maryland Shall Issue, the NRA, Delegate Valentine. We had a group try to clean up this language. And so the first part is just technical. The second part really clarifies when a licensed dealer is required to notify the secretary of a burglary, attempted burglary, robbery, or a theft of a firearm or ammunition on the premises on which the licensed dealer operates or where the firearms are stored. So we clean that up to say the theft, the burglary, et cetera, have to be of the firearm or the ammunition. And then the second part says the security feature required has been compromised. So the dealer has to, there's been a burglary, attempted burglary or robbery, or a security feature has been compromised, and we explain in detail what that means. If a failure of equipment to film and record, failure of a feature to prevent unauthorized entry, failure of an alarm system, failure of a physical barrier if it's utilized. And this just goes back to subsection A, the requirements licensed dealers have to follow if they are storing or selling firearms on their premises.
Members, you've heard what the amendment does. Do we have any questions on the amendment? No, we've got a motion. We have a motion. No, members, I see no indication of questions on the amendment for House Bill 284. Would everyone who is in favor, please raise your hand? Anyone opposed? Seeing none, the amendment passes. So on the motion, on the bill as amended, thank you. Are there any questions on the bill as amended? It has been moved and seconded. Delegate Mangione.
Thank you, Madam Chair. Quick question. If these firearm dealers are compromised now, they already are required to call the police and the ATF? Is that how it currently works?
No, I think
No.
it's only if there's the burglary or theft or there's a crime they are, but this is saying if a feature's been compromised. And I think some of the background here was that there was a truck that went through as an accident, not on purpose, and hit a licensed dealer facility and the security system was compromised. So it's trying to deal with when a security system is compromised outside of a crime, like a water, for example, flood, a power outage, that type of situation, I think is the context of where this originated from. And I'll just go back to say that we did work with Maryland Shall Issue, the NRA, and MSP, and the Dealers Association, and everybody agreed with this language.
Okay, great. I just wanted to make sure I understood correctly. So only a theft before they had report, and now it's just a compromise of some
Well,
type
it's
of
whenever they first
surveillance
hear
or-
of, if the theft burglary happens, they have to, or it's one or the other. We also have a knowledge requirement now too. Before it said reasonably should know. It was not very clear what it means. The licensed dealer has to know the crime happened or a security feature is compromised, and we list out what that compromise would entail.
Okay, yeah, the part I was just wondering, just to make sure, is when this compromise happens, prior to this bill, there was never,
No.
they had to notify local or ATF, anything?
No.
I see. Thank you.
Thank you, Holly. Are there any other questions? Delegate Valentine.
I wanted to clarify what satisfies that notification requirement. Could you just explain what makes it what is sufficient as a notification?
They just have to let the secretary know. So this is not a formal, like if there's a crime, they already have a protocol where they have to formally report. This is just a notification, just letting the secretary know that the security features have been compromised.
Well, actually, the bill language says notice. Okay, and that's all it says. It says notice. And then if you look on page 2 of 3 at section 2, it says, in addition to any report made by local law enforcement or ATF. So whatever report that is normally done for a theft, this would be, they would just have to provide notice. And I mean, it's actually flexible because that could be a phone call, that could be an email, that could be a text message. I mean, we don't need to list them out. And they get 24 hours.
Yeah. Thank you.
Mm-hmm. Any other question? Delegate McComas?
Is it possible that this would be subject to the AER committee for, under the superintendent for rules and say, okay, you've got to, write in, and then we'll send you a receipt, or we get the phone call and we're going to give you a receipt that we understand you gave the phone call. I mean, if I were the person that had the business, I would want to, phone call's great, but I want to make sure that it was logged in so nobody could come back and say, you didn't call, dude.
Right, and so that's on the onus of the duty of the person who has to make the notification. So yeah, I would think that they would want to do it by email or some way that can be substantiated. Yeah.
And the secretary will set that. I mean, they'll set out guidelines for that, I'm sure.
And council, and Holly says that the secretary will set out guidelines. Yes, yes. Okay, thank you very much. Any other questions? Seeing none. We have a motion on the bill as amended and a second. Please call the roll.
House Bill 284, Public Safety, Licensed Firearm Dealers, Notification Regarding Potential Compromise of Security Features. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes yes. Delegate Phillips. Delegate Phillips votes yes. Delegate Congolo. Delegate Congolo votes yes. Delegate Stinnett. Delegate Stinnett votes yes. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is excused. Delegate McComas. Yes. Delegate McComas votes yes. Delegate Moreno. Yes. Delegate Moreno votes yes. Delegate Arcon. No. Delegate Arcon votes no. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Aye. Delegate Simpson votes aye. Delegate Mangione. Yes. Delegate Mangione votes yes. Delegate Moon. Yes. Delegate Moon votes yes. Delegate Conaway. Yes. Delegate Conaway votes yes. Delegate Woods. Yes. Delegate Woods votes yes. Delegate Williams. Yes. Delegate Williams votes yes. The roll is 17 to 1 to 0 to 1. Motion passes.
Okay, our next bill is House Bill 351. It has been amended. Second. Are there any questions on the amendment? And first, actually, I know there's going to be questions. Let me go ahead and ask Holly if you would explain the amendments.
Okay, so this bill is actually a combination. It's House Bill 351, Delegate Moon's digital unmasking bill, and House Bill 332, Delegate Charkoudian's deprivation of constitutional rights bill. Both have had some amendments, so I'll walk you through now. The bill is called Constitutional Rights, Violations, and Digital Unmasking. The first page of the bill is actually where House Bill 332 starts. You'll see here we start under Title III, Subtitle 27 with the definitions. We just define judicial officer as an officer who may make an arrest with or without a warrant for violations of the United States Code and carries firearms in the performance of the officer's duties. If you go to page 2, it defines law for the purposes of this subtitle. And then under Title III, Subtitle 2702, this is where we say that an aggrieved party or the office of the Attorney General may bring an action against a judicial officer who, under the color of law, deprives an aggrieved party or causes or allows an aggrieved party to be deprived of a right or privilege or an immunity secured under law. We added in some amendments under subsection B and D. These were the amendments that were discussed at the hearing. You'll see we cleaned up the immunity. We said may assert any defense of immunity. There it used to have sovereign immunity. And in subsection D, we add in provisions relating to local government liability and statutory waiver. And then we also alter the statute of limitations from 3 to 5 years. So that's the first part of the bill. And the second part of the bill is Delegate Moon's unmasking bill as it was introduced, and that starts in public safety under Title 3, Subtitle 535, or Section 535. And you're going to see that's at the bottom of page 2. And this, in this part, we define judicial officer as we do in the court's article, which we just talked about. So it's the same definition. We define identifying digital data, and that was as it was defined when the bill was introduced. We also define judicial officer misconduct, and that relates back to Subtitle 27 of the court's article. And law has the same definition under Title III, Subtitle 27 of the court's article. And then you'll see at the bottom of page 3, on receipt of a complaint of judicial officer misconduct, the Office of the Attorney General, a state prosecutor, we add in state prosecutor here, or a state's attorney may direct the appropriate state or local law enforcement agency. This was the state police before, so that's been amended to say appropriate state or local law enforcement agency to gather and securely retain as much identifying digital data as possible about the judicial officer who is the subject of the judicial officer complaint. So that was also plural. We've now made that singular. It's just judicial officer versus federal agents or judicial officers. So it's just singular now. And on the last page, you'll see that we've, under subsection C, we've changed it to say, instead of complainant, it says plaintiff may obtain access to the identifying digital data in accordance with the court order issued under Title III, Subtitle 27 of the court's article, and that was the beginning parts of this bill. We've added a severability clause, and then we've also made the bill an emergency measure.
Thank you, Holly. Any questions? Delegate Conaway?
Thank you, Chair. What's the difference between a federal agent and a judicial officer?
So they wanted to have judicial officer without the federal reference to make sure that all on ICE, DHS, CBP, special federal agents were covered, and they wanted to have it more broad. I can defer to Delegate Moon because that was something that came across different immigration bills, and it just to have a judicial officer versus singling out federal immigration officer in these instances.
Okay, thank you.
Do we have any other questions, members? Seeing no questions, we had a motion on the amendment. Is there a motion on the bill as amended?
So moved.
Is it second? I'm hesitating because I hear whispering. We have any questions? We have any questions? Okay.
I couldn't remember if you said this was an emergency bill.
Oh, okay. I just want to make sure we're all good. Okay, as good as we're going to get. Okay, so we have a motion on the bill as amended. Are there any questions? Seeing none.
Oh, Conway has his hand.
Delegate Conaway, can you use your mic?
Chair, why on the first page, why didn't we change it to public safety or whatever? Why didn't it say judicial officer instead of federal agent?
Okay, so the federal agent is a narrow term.
Yes.
Judicial officer is broader.
Yes, so I'm saying why we didn't say judicial officer at all. It just says constitutional rights.
I can answer more broadly, Delegate. We were trying not to target certain agencies, so we were trying to step back and catch it a more broader lens.
My question was, why didn't we use the term?
So the reason is because if you go where we talk about the law that could be broken,
Yes.
it's all constitutional law. So it's constitutional law under the U.S. Constitution, it's constitutional law under the Maryland Constitution, it's constitutional law under the Maryland Declaration of Rights, et cetera, et cetera. So that's why.
So that would encompass the territory of a judicial officer.
Yes.
Right.
Yes, but you're asking.
Which is bigger than the federal.
Yeah.
What I'm saying is, if you look on number 2, we crossed out federal agents. So why didn't we put in, let's say, constitutional rights?
Okay, so Holly's.
That's more of a technical. You're talking about the title of the bill?
Yes.
Okay, so the title of the bill had to be altered to cover both of the ideas and concepts. The constitutional rights, both of these bills deal with constitutional rights. Because we've combined the bills together, the title has to reflect the subject of both bills now. They're both related. We did have an AG opinion on it. But yes, that's the reason. So the title is more of a technical change.
Thank you very much.
Thank you. That's why we have counsel here. Delegate Ericon.
Thank you, Madam Chair. Could the bill sponsor say which departments he was trying to make sure were not encompassed? We heard the ones that you did want to have encompassed. Who were you trying to avoid having inside the bill?
No. That's not what I said. I was trying to avoid targeting any one agency. So this is why the bill's attempting to just be broad.
Okay, so it's literally every agency.
Yeah.
If you
If
have.
you're concerned about, say, ATF, as you might be, you might have a different agency you're concerned about.
No, sir. My attorney advises me not to comment. Go ahead. Thank you so much for that.
No problem. So, but you catch my drift, right?
Yeah, okay,
it
so-
could be any agency.
Okay, so IRS or.
Yeah, exactly.
Okay,
Like I
okay.
said, you might have different agencies that you're concerned about.
I have never been audited, sir. My accountant tells me to deny this. Thank you. No.
Thank you. Any other questions? Delegate McComas. And your mic.
My question is.
Your microphone, please, Delegate
Sorry.
McComas.
My question is, okay, in the old days, we used to get the amendments in the old days with Joe and stuff, or we would get a reprint, so, because now that you're melding the two together, and I'm just wondering, I'm old, I like paper, so my concern is that I kind of don't have the ability to figure out what we took out, what we took in, and how you made the amalgam. Now, I know that Delegate Moon has one of these really good, sharp, he knows what, but I don't. So I just kind of want, Thank you.
They send them in the emails.
Well, I didn't see this one, that's why, because I looked at it early, I guess.
And it's a reprint, you might not be.
Right. So, yes.
When you say scroll down, you mean on the email?
So hold on.
So there's a PDF. Open the PDF.
No, I did. I didn't see, well, I didn't look earlier.
Right.
I looked earlier, but I didn't do anything right this minute.
No, I think I understand your concern. So that's why we have a hard copy.
Okay.
We won't always have a hard copy, but because this is a kind of dense material, we had it as a hard copy. So it's easy.
I had Delegate Simmons stuff on his, but not the other stuff. Was the other stuff on there too? Because I didn't see that.
Yeah.
Okay.
And
Holly.
I'll just say, it's a reprint because it's so heavily amended, so it doesn't look like an amendment like you might be used to, because we showed you a reprint so you could see all the changes, how they've been internalized, versus if you saw the amendment, it wouldn't make a lot of sense because the bill's been so heavily amended. So the reprint, you can see the underlines, the bold, you can see what's been brought in, what's not been brought in, and yes, it was emailed earlier, but we certainly can help later if you need help.
All righty. Seeing no further questions on the bill as amended. Take the call, please.
House Bill 351, Delegates Moon, Charkoudian, and Martinez, Constitutional Rights Violations and Digital Unmasking. The Vice Chair. Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes no. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes yes. Delegate Phillips. Delegate Phillips votes yes. Delegate Congolo. Delegate Congolo votes no. Delegate Stinnett. Delegate Stinnett votes yes. Delegate Simmons. Delegate Simmons votes yes. Delegate Boucher is excused. Delegate McComas. Delegate McComas votes no. Delegate Moreno. Delegate Moreno votes yes. Delegate Aricon. Delegate Aricon votes no. Delegate Taylor. Delegate Taylor votes yes. Delegate Simpson. Delegate Simpson votes yes. Delegate Mangione. Delegate Mangione votes no. Delegate Moon. Delegate Moon votes yes. Delegate Conaway. Delegate Conaway votes no. Delegate Woods. Delegate Woods votes yes. Delegate Williams. Delegate Williams votes yes. And the chair votes aye. Motion carries.
Oh, I'm sorry,
With
yeah.
13 votes in the affirmative.
Thank you so much. Yes.
Oh, for the co-sponsors.
Yeah, okay, this bill was amended, and oftentimes when a bill has been amended, we allow co-sponsors. However, because we have morphed in so much of other people's bills, I'd like them to kind of stay as they are and not accept co-sponsors on this one. Thank you, Della. Okay, we're going to move to, I can't look at Delegate Aricon anymore. She's going to have me laughing too much. Okay, we're going to move to House Bill 465. And there has been a motion in favor and a second, but we actually have amendments. We have amendments. Thank you. Is there a second on the move favorable on the amendment? Is there a second? Oh, thank you. Okay. So, Holly, can you tell us what the amendments?
I'm going to defer to Embry because she's been working on this.
Delegate Embry, will you explain the amendment?
Thank you. Two amendments. One responds to questions that Delegate Moon had about actual malice. So we adopted a definition from case law, Maryland case law, but that relies on Supreme Court case law about defamation. Specifically, the definition is actual malice means reckless disregard for the truth or actual knowledge of a statement's falsity. And because that included what the other piece of the definition previously in, we deleted that. So this is the actual malice, as I just defined it, is the only thing that has to be proved by the person bringing the suit. And then we changed the standard from preponderance to clear and convincing. Clear and convincing was the standard last year when the bill was introduced. And is more consistent with related case law. Thank you.
Okay, the amendment has been moved and second. Are there any questions? Seeing none, all in favor of the amendment, please raise your hand. All opposed? All right, on the bill as amended, is there a motion? Okay, it's been moved and second on the bill as amended. And I just wanted to say that the motion on the amendment was, the count was, yes. Yeah, what was the count? I know, but what was the count? I know, but what was the count? Okay, so, okay. 17, thank you. All righty, and Delegate Conaway, did you have a question?
Yes, so just to briefly surmise what this does, it says that if a person believes that someone else is sexually being assaultive or they have this behavior, they can tell on the other person without having, they have immunity. No?
Not immunity, no. So if a person who is a victim speaks about, in various contexts, but speaks about what happened to them, and the person they're accusing or the person described as the person who committed the sexual assault and what they said, if they bring a civil suit against their survivor, currently the survivor would have to prove that what they said was true. This, they still do, but in addition, the person bringing the suit, the accused, would have to show that the victim acted with actual malice. So it's a higher standard for the plaintiff, for the person accused. And the purpose of this is because in recent years, people who have been accused by survivors speaking out have weaponized this process. So they've been bringing lawsuits to punish, or for whatever reason, but they've been used more frequently.
To punish the accuser?
Correct.
Yes. Okay.
Correct. That's exactly right.
And then so the accuser would have immunity?
No immunity.
No,
it just changes the standard the person accused, the plaintiff in the case, the person who's accused, would have to show that the victim spoke with actual malice.
Okay, so I was looking at the synopsis and it says establishing an immunity from liability.
I don't know where that is, I'm sorry.
You don't know where?
It's in the, I think he's talking about the fiscal note. So that's an interpretation, if you want to look at that fiscal note.
I'm sorry,
and see if you agree with their
I
interpretation.
didn't capture, I apologize. Let's see. I don't see immunity. I'm sorry, where is that?
Go to status.
Status, okay.
He's looking at the floor system synopsis.
Oh, I'm sorry.
Sorry.
Oh, that's incorrect. I'm sorry. The synopsis on the floor system is incorrect, but the fiscal and policy note does not use
Okay.
that language.
All right. Thank you.
Thank you for pointing that out.
Good eye, Frank.
Sure.
Thank you.
Delegate Cardin?
Thank you, Madam Chair. Does changing it from preponderance to clear and convincing, so they have to show actual malice by clear and convincing evidence?
Yeah, let me just pull up the reprint. I think we sent that to you, but.
Yeah. So we're requiring them to show, not that they lied, but they lied with actual malice. And they did so, and we have to show, and we're raising the standard now from 51% to clear and convincing evidence. I'm just making sure that's what we're doing.
We are, that is correct. We're changing the standard.
Okay. So I'll just say that I think that you accomplish the same thing, which is trying to deter these by, I know that it allows for attorney's fees now, but if you just allow for attorney's fees, regardless of whether you change the standard or defined it, I think you accomplish the exact same thing without making it really, really difficult to prove that somebody is just lying. So I'm just putting that out there, that I think that attorney's fees, anybody who's doing this and spending that kind of money, they realize that it could lose, and they could lose thousands and thousands of dollars the other side. Personally, I think that's the case. I understand the intent. I like the bill. I like the concept. I just think that we may be going a little too far, swinging the pendulum.
Any other Delegate Delegate Taylor? I thought I said I wasn't going to look over there.
Trying to get some help from my seatmates here, but could you give me an example of how this would work? Just an example. This is how it works. It's just.
If, let's say, I mean, one example that was brought up in testimony that's a real example is if you disclose to an administrative body, like you're a student, let's say you're a graduate student or you're an undergraduate student, and you disclose to the Title IX office or the appropriate office in your university, and this does happen, and you describe what has occurred to you, and then the person who you say attacked you, of course there's an investigation, so they know about it, they could then sue you for defamation and related claims. So right now, it would just turn to you, the victim, to say, no, it was true, and then you just get into a contested litigation about what was true, meaning you have to hire a lawyer and go through all of the process. And this would say there's a presumption of good faith unless the person who's bringing the suit can show that you acted with actual malice, meaning reckless disregard, intentional falsity or reckless disregard.
In other words, that I am lying about potentially lying about the assault.
Because many of these assaults, it's only two people there. So you can understand how that could be challenging in litigation.
I can.
And again, the person is, they're following the procedures of their university or college in reporting. There's also examples where people have just spoken out about their experience in the context of, just trying to share their experience with others and then are sued and then, or have the litigation or facing litigation.
Thank you.
Thank you.
The Vice Chair.
Thank you, Madam Chair. I was just going to vote no. And I agree, if I'm accused, how do I prove a negative by actual malice and clear and convincing? You can't do it. It is almost impossible. And I understand your example, and that's a great example, but what about the other way? It is impossible. Impossible.
Delegate Arakan.
Thank you, Madam Chair. Presumably, there will be a significant amount of discovery in a case like this. And so what I would do if I was ever accused of this type of thing would be to ask for the text messages between them and their closest friends and family. And I would look through to see, did they ever text the person, I'm going to make this shit up, or I'm going to get this person, or I don't like them, they did this thing to me, so I'm going to hurt them like this. People that have the propensity to lie like this publicly also have the propensity to blab about it to other people. So I think the discovery process is available and would be used to prove somebody did this intentionally with malice or intentionally falsified.
Are there any other questions? Delegate Phillips.
Yeah, Madam Chair, there's a lot of debate on this one, and I know we're about to take a vote. I won't do what I was getting ready to do. Never mind.
If anybody wants to hold it, Delegate McComas?
Question, if anybody knows, Delegate Amphrey, are there any other statutes that are similar to this in other states, or are we kind of creating creating new territory here that we could rely on. We're kind of,
I don't know anything from other states. I apologize. I don't know the answer. I don't have an example from another state.
I don't have an example of other states. If this goes to the floor, we will have those examples because I just don't have my binder. My problem is I just don't have it in my head anymore.
my concern is that there are issues of proof that would have to be, and clear and convincing is a very high standard, and I know we did away with it with domestic violence. It went to preponderance, and not a preponderance, but it went to preponderance, and that was a big step, and it took a long time to get there. And I guess I'm just kind of concerned, if the victim was then, hit over the head with a lawsuit, and how are they going to defend themselves?
Okay, so let's make sure we understand what the scenario is, and then I'll give you the states.
Okay.
The scenario is that someone is falsely accusing you of a sexual assaultive behavior, okay? And you're so upset about it that you're going to take them into court. What this bill says is if you are so upset about it and you want to take them into court, then you need to make sure, and the plaintiff always has the burden of proof, the plaintiff has the burden of proof to show that this person is lying. There is a way to show that people are lying, okay? And you present your evidence to show that they're lying. You show that by the actual malice. If you cannot prove that, if you cannot show that, then you lose, and you also have to pay the other party's attorney fees. That's what this bill says. So it's the whole point behind the bill is don't haul someone into court unless you have ample proof to show that they're lying. Because what was happening is people were being brought into court, sexual assault survivors were being brought into court, and they're having to pay attorney fees, et cetera, and they're having to prove that the sexual assault happened to them. So this bill reverses that burden of proof and says, great, if you want to haul someone into court, if you want to sue them, then you have the burden of proof to show that they're lying. So that's what this bill does. As far as the states, we have Washington State, all of these, right? Yeah, Washington State, California, New York, Oklahoma, and Texas, Mississippi, and our next door neighbor, Virginia. Delegate, does that answer your question, Delegate McComas?
Yeah.
Okay. Yeah. Delegate Conaway?
Could you make that just a little more clear? So you have the one person who allegedly did the sexually aggressive thing to the other person. The other person is the survivor, right? The survivor accuses the first person of sexually assaulting them.
And the person who is accused of sexually assaulting them then takes the survivor to court for civil damages.
Yes.
And so if you're going to do that, then that person who is the accused needs to have proof to show that the survivor is lying.
And if they don't have the proof?
If they don't have the proof, they lose, and they have to pay the survivor's attorney fees to be there to defend their case.
Okay.
Okay?
Yes, thank you.
Delegate Simpson?
Just to be clear, I know you were presenting a case where someone felt that they were innocent, but it also goes the other way in which the individual, this is something that has happened to them, and perhaps they didn't. We know that often survivors do not report until they are safe, or they may never, report. But when there is that power or that economic imbalance, and we know there were non-disclosure agreements, and we took care of those, and now this is just another way, another layer that often that they continue to abuse this individual by silencing them.
We had the Me Too movement in 2018 in which people realized they were not alone. And then, individuals who may have abused many people were using the courts to further abuse them. So,
Right.
It's both sides. Yes, there is a possibility that it is someone who is falsely accused and the burden of proof on them, as opposed to the individual who has endured not only being abused, but then they are being silenced. So that's why the bill, I would say the spirit of the bill.
Right, and I just wanted to add one more thing before you. Keep in mind that any of the individuals in the Crime Victims Act, if they talk about what happened to them, just as they were sitting here yesterday and telling us what happened to them, they could be hauled into court. This bill says that if you're going to haul those victims into court, you need to have proof that they're lying. That's what this bill says. Okay, I promised Embry, but if you wanted to continue that thought, Delegate Embry, do you mind?
I did want to share, we have had, given, the nature of the bills that I often put forward, we do get requests where victims have come and told their story, and especially young victims who have told their story and have asked for their, their written materials to be to be removed when they realize that possibility that they actually could be further harmed.
I agree. Delegate Embry.
Not a situation where a victim is suing an aggressor, which does happen, of course.
Right.
In that, where they're taking the action to try to, seek damages from the person who sexually assaulted them, the standard is the same. The burden is theirs, absolutely. This is only when, just from speaking out, the person they're talking about brings a suit against them for money and damages. So I just want to make sure that's clear.
Delegate Taylor.
I don't know why my soul's not settled with this, and I'm a co-sponsor, so I don't know why all of a sudden. What I'm thinking about is the situation where it is a lie. Like, you have accused me falsely. I didn't sexually abuse you. My name is smeared, and I don't have enough money to fight you on it.
Well, then you can't bring this case. You wouldn't bring this case. You would bring a different case. You would go to a state's attorney or someone else if you wanted to go with malicious prosecution or something else, because perhaps if the result of that action resulted in some type of penalty or crime or something like that, then you could sue under some other tort, but you wouldn't be able to sue under this tort because you can't prove it.
Got it. So there's another manner in which I can be made whole or get some justice.
Maybe not. I don't want to mislead. Maybe it could be or could not be. It depends on the factual circumstances for that particular person. But in this case, you have to be able to have proof that the other person is lying.
Thank you.
Yeah. Delegate Phillips.
Okay. Because and I hear you about Virginia. It appears that they did theirs a little bit different, and I understand the challenge. So if I'm reading correctly, the way they did theirs to protect the speech was to put it under the concept of an anti-slap and immunity statute. And that immunity was very specific about matters of public concern, public hearings between governmental bodies, and I like this, made at Title IX hearings or in employment. So it brought in those things very specifically. This is really broad, and it just gives me some concern that it could be used.
Like, just tell a friend.
Yeah, just tell a friend, and yeah.
Okay.
Do we, is it, so my sense is it's not, for us, it's not really narrow as to where the speech might go and who might be told and how it might be used.
Okay. Let me just ask one quick question. Did you also look under the definition of sexual assaultive behavior under 10-923? Look under there, and then Delegate Embry, if you wanted to respond.
I think Delegate Phillips in part answered his question, but the problem with our SLAP in Maryland under our SLAP statute, it really is restricted to, as you said, sort of more public matters. And these victims speak in all kinds of contexts. So we just want to make sure we are containing all of the situations in which a person might be sharing their story.
So there wasn't a consideration to just expand SLAP? I mean, yeah, SLAP, anti-SLAP.
In previous years, I would defer to, this bill was introduced last year and this year, I believe, in this form, but I believe there was consideration of.
I'm sorry, what was the question? I was reading testimony that explains why they didn't use the SLAP method.
I was just answering that that the reason we didn't in this state and in the statute is because it is narrow in terms of what would be covered within SLAP. And this, we wanted to cover more broadly the ways in which a victim might share their story.
Okay. Holly, can you read that section? Because I'm not absorbing it. This is Delegate Phillips, this goes to your question about anti-SLAP.
So this is from the National Women's Law Center. It was in their testimony. It says House Bill 465 closes the gap and ensures fairness. Under House Bill 465, people who allege sexually assaultive behavior will be protected from defamation and other civil liability if they act in good faith. Example, without actual malice, intent, recklessness, proven by a preponderance of the evidence. In addition, they will receive attorney fees and court costs. If they are sued for making those allegations, this ensures that sexual assault survivors can freely report in the first place, just like any other defendant under Maryland's existing anti-SLAP law. At the same time, House Bill 465 allows people who are falsely accused of sexual assault to pursue meritorious defamation lawsuits when they can establish that the accusations were made in bad faith, just like any other plaintiff under Maryland's anti-SLAP law. In other words, House Bill 465 treats all parties fairly. And then to Delegate McComas's question, I think it was Delegate McComas, at least 15 states considered similar bills in 2025. And then California, Connecticut, Maine, New York, Oregon, and Virginia have all passed very similar but different bills within the last couple years, few years. And that's all in their testimony, so you can look that up.
That was the National Women's Law Center. I don't know. I think the vice chair was next.
Thank you. So we're having a discussion, and we're talking about victim and perpetrator like we know who they are. There's an alleged victim, right? There's an alleged perpetrator. So there are allegations, and it's assumed that the alleged perpetrator, the alleged victim is telling the truth.
Is lying. You have to say lying. No. I'm sorry. Keep going.
That the alleged victim is telling the truth unless the alleged victim is telling the truth unless the other person can prove that they're lying by actual malice and clear and convincing evidence, which is almost impossible. That's the problem.
Delegate Conaway?
What is the meaning of sexually assaultive behavior?
Did you go to section 10-923?
Well, I'm trying to
can go
figure
there.
I'm trying to figure out is grouping?
No, well, let me go to 10-923, and we'll see. Are you pulling it up? Okay, thank you. In the meantime, Delegate Moon?
Thank you, Madam Chair. In the amendment, I'm just curious about the standard. You said the standard changed, right? In the amendment. I guess, can you just talk about the reason for that and how important that is?
I don't know that it's incredibly important. It was originally, the bill, as originally last year, was clear and convincing evidence. I believe it was changed based on, I don't know, a number of conversations, but.
And then this year it started as preponderance and went back to clear and convincing.
Based on conversations with advocates, but it is not, I
So
would
I
be
guess
comfortable with preponderance if that's.
Well, and I'm just thinking, I'm just sitting here trying to think of real world cases, and I was thinking of like Dominique Strauss-Kahn is one case, and then there was some case, maybe it was the Duke lacrosse case, I think, right? Where you had questionable facts come in, and I'm just trying to think through, you have a case like that come in, and I'm not saying that what happened or didn't happen, but it's as to whether someone should be immunized when facts like that come up would be the question. And I guess the argument is just what the standard of proof should be. And so I just wonder, given these questions, if we shouldn't revisit the standard of proof to allay some of these concerns. And if that would be amenable to folks, would make people happy, we could reconsider the amendment with that modification.
And I'm sorry, Delegate Moon, was the modification to move back to clear and convincing?
To move it back to preponderance.
Oh, I'm sorry, yes, I meant to preponderance. In fact, that's the conversation I was having.
Yeah.
That we're going to, I want to go ahead and put in an amendment we're going to hold it and put in an amendment to go to preponderance of the evidence and remove clear and convincing, okay? So we are going to do that, but I will continue discussion since we're going to hold it and amend it anyway to see if there's anything else anybody else has to add. Delegate Conaway and then Delegate Cardin.
Oh, I was trying to find the answer to my question on the Title III. Oh, go ahead.
So sexually assaultive behavior is under 10-923, a sexual crime under Title III, Subtitle III of criminal law.
Yes.
Sexual abuse of a minor, sexual abuse of a vulnerable adult, a violation of 18 U.S.C. Chapter 109A, and that's aggravated sexual assault, and then a violation of a law of another state, the United States, or a foreign country that is equivalent to an offense under the ones I just listed.
Right. So in reference to number one, a sexual crime under Title III, Subtitle III of the criminal law article, does that include groping? What?
Does it include fourth degree? That's
Yeah.
Well, does it
Yes.
include fourth degree?
Yes.
Okay. Thank you.
Yeah, I mean, I can go, yes, I can, there's a long list, but okay.
Okay, for purpose of the discussion, Delegate Conaway.
So in reference to the example we're given, if Party A touches Party B, like let's say a gentleman touches a lady and she has on one of those dresses that doesn't have a shoulder on it, and they rub the shoulder or back or something like that, and the Party B says, Party A groped me or inappropriately touched me, then that could lead into this.
There's another step to that. So after Party B said Party A groped me.
Yes.
Party A now takes Party B into court for civil damages for saying Party A groped me.
Right, okay, can we pause right there real quick? So in reference to what the good delegate across the room said.
There's lots of them over there.
Directly across. So if the party that believes that they were groped tells their friend, and their friend says, you shouldn't have did that to my friend, now you can bring this suit against them.
No, not quite. You're almost there. So now Party A brings in either one of those two parties, the first party, B, or the one that person that B told, C.
Yes.
Okay, Party A would sue B or C and for damages. If Party A were willing to do that, then Party A must show that Party B or Party C were lying. Meaning that I didn't grope you, I didn't touch you, I didn't do anything to you, you're lying.
And then
If you can't-
how do you prove that?
How do you prove that a person is lying? You don't, look, here's the thing. If you're bringing them into court, there's two things that are happening, and that's the doctrine of unclean hands that we were talking about yesterday. You're saying that this thing actually happened, right? So you're saying party A is saying that either we were in the same room together, but I didn't really touch her, or I never was anywhere around, and I'm saying her, but you know.
Yes, I got you.
And I was never with party B. That just never happened. Well, it would be very easy, and you have proof. I bring in the vice chair, and the vice chair can attest that I was at a dinner with her when party B is saying that I was doing whatever I was doing to them. Therefore, I have proved the lie.
Let's use the other extreme. You were in the room and you have a picture where you have your arm around the person. So and you were there and you have some sort of contact, but this person says you touched them inappropriately and you saying you didn't, but they told their friend, and now this thing is starting to spread. So what is your recourse?
Well, now I'm going to have to prove that they're lying. And I could probably ask some of my friends. I could probably I'll try to prove that they're lying. Or I just don't sue them. Right. There's that option too. I don't have to sue you at all if I don't have the proof.
Right.
And quite frankly, that is no different from any other civil case. The plaintiff always has the burden of proof. They have to prove that it actually happened. Not only did it actually happen, but it happened by the person I'm suing. That's always a burden that the plaintiff has in a civil case.
Okay.
Yeah. Delegate Moon?
Yeah, I was just going to clarify. I mean, part of what this bill is trying to guard against is the fact that it's pretty well known that it's a common damage control tactic to say, I'm going to sue, just to cloud the air. Even if you may have done it, right? You may want to sue just to protect your reputation because it might not be provable one way or another. So the question is now, if we're going to grant immunity to someone in that situation, what should the standard of proof be? And so the situation we're setting up is, all right, you're going to go out and accuse someone and they're going to sue you. And this bill would say, basically, if you're going to sue someone, it can't just be to silence them. You better come with some proof. And I guess the question is, should it be a preponderance or clear and convincing? Now, I would concede if you have no proof because there just wasn't any evidence possible and no one communicated everyone, then we're in this land of who knows what actually happened. But that's currently the case, right? And so what's happening is these sort of suits automatically happen just to cloud the air. But again, as to your question, how would you prove it? I mean, there are cases where people have brought in evidence, and this is why I said the Dominique Strauss-Kahn case is one, the Duke lacrosse players is another, where there was, and again, I don't know if these facts were true or not, but there were cases where facts later came to light that someone could use to call into question. So if you have some proof like that, or evidence, I should say, you may be able to bring it. And again, I think if we want to do a bill like this, we have to just decide what the standard of proof is that you need. But the policy decision we will be making is that you have to come with some proof if you're going to try and sue someone.
I said Cardin next, and then I'll go to Erica.
Madam Chair, and I appreciate the hold for the consideration of preponderance. That does make a difference for me personally, number one. Number two is, all the SLAPP suits have come to me over the years. Sandy Rosenberg brings them every year. We took bad faith out of the SLAPP legislation. So if we decide to go that route and expand, we were talking about expanding Grace's law and just a case to avoid some other issues as a possible way of doing something. If we expanded the SLAPP suit to include, like Virginia did this, that may be another way of doing it that doesn't do violence to the conscience of certain people. But my concern is that and I understand the intent of the bill, and I love the idea of the bill, but my concern is not the reporting or the telling people in an official capacity or telling people in a formal way to try and deal with the situation. It's the gossip or the fact that this is very broad, and it could be any kind of telling this that could, and with social media the way it is right now, you never know, you could, I mean, again, you look at Prince Andrew, who, by the way, I believe is guilty, or the former Prince Andrew. But if in fact, let's just say for the sake of argument, he's not, he's guilty, but if in fact he wasn't, think about how his life was completely destroyed by that. And that's not, I'm using that example only because it's in the news. But like, if somebody goes out there and does this and does it on social media, you could destroy somebody's life with one social media post. And that's, and it might not be provable because it's all gossip.
Yeah.
And that's why, so.
That's true. That's absolutely true. Delegate Arakan.
Woo. Thank you, Madam Chair. I just want to, I know we're going to work on the standard of evidence, but I'm sorry, the preponderance of evidence, but I want to caution against any chipping away of the things included. There was some discussion of fourth degree being included. Victims will absolutely not know what they're allowed to talk about if we chip away at that. So if that happens, it will render this policy completely useless to the victims because they will not know what they can and can't say if we chip away at anything, because a lot of times when these crimes occur, multiple levels of crimes are occurring, including fourth degree. And if you take away their ability to talk about that, it really damages the entire law permanently. So I just want to caution against any chipping away at that part of the law.
Okay, any other discussion? All righty, the bill is held for purposes of amendment. And one last thing, everybody got a copy of House Bill 1341, is that correct? No, that is not correct.
Yeah, I haven't sent it out yet.
Okay, we're gonna wait until the hearing. Okay, all right. So everyone, if I could just get your attention, we are going to have a vote session on Tuesday after our bill hearing. Don't know how many bills we have. We have a lot, so prepare yourselves accordingly. There may be refreshments provided, but we're going to be here late on Tuesday. And so we will have a vote session, and that way we'll be able to revisit this. All righty. Thank you, everyone. We are adjourned.